We're live.
So just wanted to start off by saying hello to everybody. We have a couple of participants rolling in, so we're going to wait a couple of minutes and Dean Page is going to start us off with some introductions. So maybe 1 or 2 minutes, we'll wait for the participants to keep coming in and we'll begin.
We're all so quiet.
Okay, I think most of our participants are in and the numbers can still increase a little bit more. So I'm Anthony Page and I'm Dean at FIU's College of Law. And this is National Estate Planning Awareness Week. So welcome to today's panel discussion on estate planning. And thank you all for being here. I'm delighted to highlight a few of our incredible alumni who are working in this area and look forward to an informative event. Who needs an estate plan? I'm guessing we're going to learn probably most people. What you need to know when establishing an estate plan and what can happen if you don't have an estate plan. Thanks to Jasmine Grant from FIU Law and Livia Souza from the FIU Office of Estate and Plan Giving for putting this event together. I should let you know it is being recorded. Thanks also to our panelists and our moderator for volunteering their time. And at this point, I'd like to introduce our moderator. Melissa Gonzalez is a double Panther. She obtained a bachelor's in finance from the College of Business and graduated from the College of Law earlier this year. Among other things, Melissa was very successful in negotiations, ADR, and counseling competitions. And I last saw her a few weeks ago when she was a judge at our negotiations competition. So thank you for that belatedly as well, Melissa. Like many of our recent graduates, Melissa planned to take the bar in July, which was then canceled, converted to online, postponed to August, and then finally held 2 weeks ago. But she has just told us 40% of the bar was on trusts and estates. So I think that augurs well. Good luck, Melissa. I'm sure it will be fine. She is employed at Morgan Horton Law in Coral Gables, where she has worked in estate planning. And at this point, I would like to turn it over to Melissa.
Thank you, Dean, for that. Appreciate it. Welcome, everybody. Thank you for joining us on Zoom. I know it's a little different from most years. With COVID, a lot of things have been changing, but we're really grateful for everybody to join us today. We have 3 amazing panelists. We have first Leslie Marenco. Second, we have Sama Abukadir. And third, we have Leanne de la Riva. And as you could see, we have a all-women panelist this year. We're very grateful to see that you 3 attorneys are really thriving in the estate planning field. I'm going to hand it over to Leslie Marenco first. If you would please introduce yourself, a little bit of background, and where you are currently employed.
Sure. Everyone, I'm Leslie. My firm is Trust Counsel, and that is actually a recent rebrand as of about 1.5 years ago from what it used to be, which was the name of all of the partners, Marenco, Warshawski, Padron, Rodriguez, et cetera, et cetera. And we've had our firm now for almost 7 years. It'll be 7 years at the beginning of next year. We're a group of really both domestic and international estate planning attorneys. Our office is in Coral Gables. Not that that really matters anymore, since most of my time is spent on platforms just like this, zooming it up with potential clients, referral sources, and other centers of influence. I'm specifically on the domestic estate planning side, and I focus a lot on business owners and people that might actually be above the exemption very soon. So thank you for having me.
Thank you for that. And Sama, could you follow up with an introduction of you?
Sure. Hi, everyone. I am Sam Abukadir. I go by Sam because it's just easier for everyone. I own the Florida Probate and Family Law Firm, which is also in Coral Gables, not that it matters. I started my firm almost exactly 2 years ago, actually, a little over 2 years ago. Half of my practice is probate, the other half is family. We help people going through the toughest times of their lives, death and divorce. We are a group of 10 people now at the firm. There are 4 attorneys, paralegals, assistants, everyone. And we focus our time just trying to help people on both sides of the practice. So I've seen that sometimes when people are going through a divorce or a family custody matter, they usually need some help on the probate side. So that's where the idea came from. Thank you for having me.
Thank you for that, Sam. And Leanne, could you introduce yourself, please?
Sure. My name is Leanne de la Riva. I do guardianship, probate, and estate planning. I am at Markowitz Ringel Trustee in Hartog in the Dadeland area. We actually are trying to get back in the office, but we're not seeing clients, so it actually doesn't matter. And a little piece that I'd like to share with everybody is that I am a triple Panther. In 2013, I graduated from law school. In 2008, undergrad. And in 1991, I had to ask my mom, I graduated from the Learning Center, which is right across from the arena. So fun fact, been there many, many, many years.
I love that.
Thank you for having me.
Well, I just wanted to say thank you guys for being here today. I know you guys have been extremely busy this year and taking the time to be with us during the lunch hour. I also wanted, again, to welcome everyone who was watching. Before we get into some of the legal terms and, going into estate planning, I just wanted to say that for every viewer that's out there, estate planning is not just for the retired 85-year-old or the 1% richest in the world. Estate planning really is essential for everybody. And at any time when you have minor kids or when you're going through a divorce, like Sam was saying, these are the times where you really could consider estate planning. It doesn't have to be, you don't have to meet this criteria before you start thinking of any of those estate documents. But so before coming in today, I wanted to do a little bit of research and kind of see where the community stands in, does the community know a lot about estate planning? How many Americans actually have wills and trusts? And so a survey according to caring.com said only about 40% of Americans even know what estate planning is. And ever since the survey, which was in 2017, 25% of that number has decreased. Now, I'm sure, unfortunately, with COVID, this year has been a little bit crazier than others, and it's definitely a topic where I feel a lot of people are more interested in learning. Even if they don't come in and do a will or do a trust, it's coming across more people's minds and in conversations to really know, okay, well, what does a will do, or what happens if I do pass without a will? So I think that this was an awesome event. I'm really excited for everyone to be here and just to learn a little bit about what Leslie, Sam, and Leanne do. So this leads me to my first question. If Ms. Abukadir, you could answer this first. I just wanted to address first, what is estate planning? Kind of simple terms. And why do you think that not a lot of people understand estate planning, have wills, or know in part, like not a lot of people discuss the topic in general? And why do you think that?
Sure, thank you. So estate planning is having your documents in order if anything were to happen to you during life or post-death. So that could include, depending on each family and each situation, it could include different documents. But the core documents, in my opinion, are having a last will and testament, a revocable trust if that's needed, a living will, which people get confused all the time with a last will and testament, a durable power of attorney, and a healthcare surrogate. And then if you have minor children, it's always important to have pre-need guardians in place if anything were to happen to you. To answer your second question, I think personally that people don't see the importance of estate planning because they don't think that they're going to pass away. I mean, you're young and you just think, and even when you're older, actually, sometimes it's a cultural issue. People just don't see it as something that's important. It's not top of mind. It's not something that we talk about. And the second that we do start talking about it, I'll give my parents as an example. The second that I did start talking to them about it, and they know I'm an estate planning attorney, they were like, the second we sign, we're going to pass away, Sam. We just don't want to think about it. We don't want to deal with it. And I know that Leslie and Leanne are smiling, but it's funny because in South Florida, I get that same thing with clients that come in. They're like, we're too afraid to actually execute and make sure anything's in order, even though we know we need to do this. So that's part of it. And the other part of it is education. A lot of people, just like what you said, don't even know what estate planning is. And it's just something that we need to do a better job of educating the community with. If nothing, COVID has educated everyone with the importance of estate planning. And I think that this is where people start to understand, okay, if something like a pandemic comes along, I really need to make sure that the people that I want to inherit really do inherit.
Totally agree, Sam. Like you said, it's not just, post-death documents. These are lifetime during documents. So if, God forbid, you just went to the hospital for something and you needed a healthcare surrogate, that's a decision that you would need right away. So it's not just thinking, of death is such a strong word. These are lifetime documents that people need on a daily basis. Which this actually leads me to, maybe the community doesn't know too much estate planning, but then we think of celebrities. And when we think of celebrities, we think they have 1 million attorneys, they have all their estate planning documents in order, probably in a beautiful folder in a safe. And I came across Leslie's blog, and she always writes about newly passed celebrities and how it's so surprising that not even them have estate planning documents. So Leslie, could you explain to our viewers what in fact actually happens to someone who passes away without any kind of estate documents?
Sure. And I get that a lot, Melissa. I mean, this newsletter, this blog that we put together every other week, that is generally based on some type of celebrity estate, or like the last one we put out was actually the lawsuit and kind of an estate lawsuit against our own president, right? So it's always something that's interesting to read. But I get that exact comment a lot. Like, how could this be possible? These people have tons of money. They have access to the best advisors, you would think, right? Attorneys, CPAs, financial advisors. But I would actually say that I don't think that's the case at all. It's not surprising to me at all. And I think when you've been doing this long enough and you start to see the patterns in your own clients, and whether these are, you could say celebrities or kind of creatives or whatever it is, right? Or even, more, I guess, just generally somebody that is a business owner, and you start seeing that pattern in personality, and they're not in the weeds and they're not thinking worst case, and they're risk takers, and the thought of them dying, prematurely is just not coming to mind. I think also, we have a very, of course, Latin American community here in South Florida. And there's a huge difference between their civil law, their countries, which they don't control a whole lot after what happens after they die, versus us, right? So there's a lot of education, as Sammy was saying, that goes into this. To your question, which is what happens if you don't have, an estate plan versus if you do, let's say on the best case scenario, what happens is some unnecessary costs, some unnecessary delays, some frustration. You know, the state of Florida, every state has a plan for you. If you don't make a plan for yourself, you're just going to have to go through the succession procedure here in the United States and the state of Florida, which is our adorable probate court, right? On the worst case scenario, I will tell you what's going to happen is, like I like to say, chaos, mayhem, and possibly foolishness. Because when people don't really know what it is that you wanted, or, you know, depending on the family dynamics, you can end up in years and years of litigation, wasted time, money on attorneys, and everything else. Even in times where you think, you know, my kids all love each other and they're all great. I don't do any probate, so I'm sure Sammy and Leanne can speak to this much more than I can. You know, the things that you hear later of everybody fighting over stuff that means a lot to them. And I guess mom gave one a bike and didn't give the other one a bike, and one got a pony, and all kinds of things, you know, that are really very similar to family law. I think it's really interesting, Sammy, that you ended up, you know, doing both of those things, because I feel like at its emotional core, they're the same type of thing, right? These are all very, very deep and personal family relationships. Of course, I always say I'm on the planning side. I practice happy law. I'm not really the one that's going to be dealing with anything on the other end. But it's always so much more. I feel like it's just easier, cheaper, just do some planning ahead of time than what's going to happen later on if you don't.
Yeah, definitely. Thanks, Leslie, for that. Like you mentioned, you know, we're dealing with people who are kind of at their worst times, right, Sam? Whether it's a divorce or whether it's death. And, you know, in the process of grieving, now people have to think about, okay, who's going to get this? Who's going to get that? It gets really ugly. And I actually heard a quote from a judge one time. She mentioned, you know, criminal court is bad people on good behavior, but family court is good people on bad behavior. So that always stuck with me. I think that, you know, in these times, especially where a family is mourning, or Sam, or a family is going through a really tough divorce and legal custody battles, the last thing you want to be thinking about is, where is this money going towards? It's going to the cousin that we've never talked to in 3 years. And so it can get very hostile very quickly. But that leads me to the third question, Leanne. What would you, I guess, you would offer, or you would tell the audience to consider when planning an estate? So what are the main factors or key takeaways that you would tell the audience to consider when they are planning for their will or their trust?
Okay. So I see it as maybe like building blocks. And something that I think hasn't been mentioned and is so critical in Sam and I's practice is avoiding a guardianship. And that starts with the advance directives. Advance directives are a combination of 3 documents that let somebody make decisions for you. You should be getting that when you are 18. You're going off to college, you're registering to vote, and you're getting those documents signed. Next would be doing what your practitioner feels is the right plan for you, whether it's a will and a trust or just a will. And I think the most important part there is either funding your trust, making sure your assets are in the name of the trust, or retitling assets, retitling accounts, and making sure what you've spent your money on actually happens. I think those are the 2 most salient takeaways that I can share with the audience now. And I can see Leslie nodding along and kind of chuckling with the funding of the trust, because I think, you know, if you don't put your assets in the names, you know, in the name of the trust, or you don't retitle certain assets, maybe when you're getting divorced, but you're not divorced yet, or maybe you put things in a boyfriend's name or a fiance's name or a friend's name, and then you have a child and you don't come back and look at these documents, you are going to be calling somebody that does probate, and, or not you, but your child probably will, or their guardian will, and it's pretty complicated at that point.
Thank you, Leanne. When I heard when you turn 18, the first two things you do is voting and advanced directives, I couldn't agree with you more on that. This is kind of like an open question. I know a lot of the comments hindered on a durable power of attorney and a healthcare surrogate, but could we break that down and kind of explain in simple terms, what do those documents do? If anyone wants to take it.
And I can take the healthcare surrogate or the durable. I'll start with the healthcare surrogate. So that document basically allows you to choose who will make healthcare decisions on your behalf. If anything were to happen to you and you're not able to make those decisions on your own. So the way that I like to explain it, just like what Leanne just said, when you're 18, this is such an important document because when you go off to college, God forbid you get in a car accident, your parents can't make those decisions for you. Once you turn 18, you're an adult, and people don't understand this. So if you just have this document handy, and it's not anything complicated, it's just something that you sit down and you discuss and you make sure that you choose your primary person and then a contingent or a secondary person just in case the first isn't able to serve. Then if you're in the hospital or if you're not able to make those decisions, this immediately comes into play.
Perfect. Additionally, Leslie, I know you're more on the estate planning side. Could you discuss a little bit about charitable opportunities and the benefits of some charitable bequests that could be put in someone's will or trust?
Sure. And actually, I mean, right now, as this year has created some amazing opportunities for some higher net worth clients that do have some charitable inclinations generally. I mean, it's created a lot of opportunities for a lot of high net worth clients in many different ways. But certainly, if someone wants to leave something to a specific nonprofit or a specific institution, it's not something that I think here in South Florida, at least, I don't get a huge amount of that. But I do have a lot of friends that do exactly what I do in other states that get a whole lot of that. And those people usually have a tie to South Florida, which is always an interesting dynamic that we have with the New York, New Jersey, the Massachusetts, et cetera. So a lot of times that's such a personal thing. I think it's a cultural thing. I think it's if your family, if you were raised in that environment where those kind of charitable things are important and what is important to you, I have a client that gives an obscene amount of money every year to Wikipedia, and I thought that was pretty fantastic. Actually, I'd never heard that. I have definitely a bunch of clients giving to, what is that pet thing on TV where the lady's singing? And yeah, I don't have time to watch too much TV, but apparently there's a big, is it Humane Society? I really don't know. But, they give a lot of money to that. And in their estate planning documents is a whole lot of that. But if you, generally have some tax concerns because you're anywhere near, let's say, the 2026 exemption, or you're concerned now that maybe we have a different political climate and different tax climate coming up, there are a lot of different strategies that you can employ. And if you have charitable inclinations, it's almost like a double benefit, right? So
Definitely. I think, like you mentioned, depending on, the next political candidate, there's so many things to think about, which would lead to, when should a person actually review their estate plan? I know that, they'll come once, they'll say, hey, I did a will, I'm done, I'm never coming back. And then, we get either a new president or the legislation changes. And so when do you think, or Leanne, what would you recommend to your clients as a time frame to kind of revise the estate documents that they've signed?
So I have a general rule. Ooh, there's feedback, isn't there?
No, I hear you good.
Oh, okay, good. Then it's on my end. I have a general rule that it's when major life events happen, death, divorce, birth, majority of a child, those big things. You buy something like a house and you don't tell us, and it's sitting outside in somebody else's name. You start a business, you start a firm, things like that. That's kind of the general rule. Then I have certain clients that I know are creeping up to that threshold where you may need to do something else. You know, your business takes off, you have more children, you start or you get married into a blended family. That's on the horizon for you. I try to make it easy for them and say, when you're filing your taxes, you're going to look at the plan and see if it makes sense. That's kind of my two buckets of people. I think if I start telling them every time there's a new president, or if I even mention a new law, they will not call me back.
You know, I
Got
like
it.
to tell people generally that I know are going to have recurring either buying and selling certain assets, or exactly what you said, there's certain life events that trigger. This is not that rotisserie machine. You are not setting this and forgetting it. Do not think that you come in here once and you sign your documents and you're never going to hear from me ever again. I'm pretty annoying to my clients sometimes, I think. I mean, I have a pretty robust CRM too, which makes me even more annoying because they're going to get certain emails and I'm going to program certain things right there at the end of that engagement that trigger things for me to remember about that client. Almost, this person's between this level of wealth and this level of wealth, and we're going to have another conversation or what it is, because exactly what Leah just said, people don't want to hear from us. It's kind of like if we call them up and tell them, oh, the tax laws, the Secure Act passed in December. They don't care. They don't want to know unless you're specifically going, this is going to cost you a lot of money.
Right.
And you have to have kind of a way to have that relationship ongoing with your clients. People think that all we deal with is kind of course, we're planning for death, but there's a whole lot of tax things that go on throughout your life, transfer tax wise, that just short conversations with your estate planning attorney can probably save you a lot of money. So, don't be scared of us.
I completely agree with what Leslie and Leanne said. The problem is people think that once it's in place, they're good. They're done. Everything's taken care of. They have nothing to worry about. And then that's where Leanne and I come in when there's litigation when the person passes away because they had a falling out with someone and they forgot to change their estate planning, or someone passed away and the kids of that person now come along. Yes, Anne?
Or my favorite, they make the change on the document, but they don't do it correctly, which I don't even like to say that there's a correct way of doing that.
Yep. They do it themselves.
Right. They literally will write like, this part is void.
Yes.
But maybe, or see Word doc saved on 10/10/1978 or whatever. The other example that you just reminded me of, I know we're going on a tangent, Melissa, but this is what happens. What happens when you name somebody in your healthcare surrogate? Let's say you name your mom and your dad, and mom and dad pass away and you never come back and see me. Well, now we have to go get a guardianship for you because there's nobody to make your healthcare decisions. So these are living, breathing documents, but you got to make sure that they're in good standing.
Correct. And it's also super important when you have minor children. I mean, this is just estate planning 101. Don't leave your minor children as beneficiaries to certain things because you're going to cause a guardianship, just like what Leanne said, to have to be established. These are conversations that you have in your initial consult with your estate planning attorney. Most of us offer, some sort of free consultation or something like that, or even a paid consultation, but that's something that's going to save you thousands of dollars down the road. So it's just, I don't know, you see all these horror stories like everyone's saying, it's just important to just have a conversation.
Yeah, I definitely think it's important, not only to, if let's say an attorney is out of budget and you want to do a free form online, at least get the advice from an attorney or try and seek, some kind of legal advice. But I heard, Leanne, you said, people will make a trust and then they don't fund it. And I kind of want to get into that a little bit. I want to talk about particularly, when you make a trust, you already have all these assets, right? Now we got to start pulling those assets and putting them into the trust. So what kind of steps would you advise the viewers should, like, in renaming or making sure that they are putting their assets in the trust? And we have life insurance policies, we have titles of houses, thinking of funding the trust, they'll say, oh, my life insurance policy, I'll put that in my will. But what they don't know is they have a named beneficiary already, and they have a contingent beneficiary. And so they think it's going according to the will, but it's actually going according to who they named as a beneficiary. So if anyone would like to address that topic, I think it's important, because a lot of people have the misconception where, oh, my house is named with my best friend, but in my will it says, oh, I'm leaving it to my mom. But your best friend has part of that house now. So if anyone would like to address that.
I just want to say one piece to go off of what Sam was saying, and then Sam and Leslie can jump in. This is part of that first initial meeting, that first convo that I do have with the client. And what I like to do is list out the assets and tell them let's go through how you believe they're titled and what would happen if you died right now with no will, with a will, or with a trust, so that they're able to see the example through their own assets and understand this bank account that you share with mom is actually just on there as a signer. So that actually doesn't belong to mom. This house that you bought with your college roommate, you guys own it with joint rights of survivorship. Mom isn't going to inherit your 50%. So I think that's the best way to really crystallize the information. And it's something that you do in that, like Sam was saying, my firm does free initials. It's part of that first conversation where you're really addressing what you may need. So I don't know if you guys want to jump in on funding the trust further.
Yeah, I mean, I think it's one of those things that people, even other attorneys that don't really do what we do, or attorneys, that dabble in multiple areas of law and will end up doing some type of simple will for people or whatever it is. And we all come across clients like that have done some previous estate planning documents that just make no sense when you start looking at the assets themselves. Because the clients, I mean, people generally have no idea, like, this is great, the will says X or the trust says X, but how are things actually titled right now? And some of those designations trump, like in real estate, like what Leanne was saying. If it's already a piece of property and it's titled jointly with your best friend from college as joint tenants, like, it really doesn't matter what my will or trust says, right? So we have a separate funding meeting where we kind of break down all of the assets after the clients have disclosed to us what it is that they have, where are their bank accounts. And sometimes they're kind of annoyed that they need to go to Chase and go argue with some banker that doesn't know much about much, and tell them what it is that they need to happen, right? Because by then they're very educated and they know what they need to do to go fund their trust. But without that information from your attorney, people are just not going to know, and things are going to go in places that they never would have thought. And that definitely will cause litigation. 100%. I mean, we see that all of the time. Somebody will call the office and go, I don't even know why uncle still has his name as beneficiary of the policy. That's clearly for me. And there's 16 emails from my dad to uncle saying, that money was mine. And now uncle's taken off with the money. Uncle's not giving it back. Right. So that was a call I got yesterday morning. So, you see these things all of the time. They're not coordinated. You must coordinate your assets with your estate plan. Ultimately, I think what people are paying us for is not the will. You can go get off LegalZoom for whatever it is. Is it $500?
$29.95, something like that.
Lord. Okay. So
What?
That is not what you are paying me for. You are paying me for advice so that your stuff is not all totally messed up, because you don't know what you don't know, and you don't even know where to begin with all of these things, honestly.
I just want to add to the $29.99 before you, sorry, Sam, but like, lo barato te sale caro. Like, my grandmother always says that. What is cheap will end up costing you so much more in the end. And that $29.99 or whatever it is going to be, I don't even know. If we're in litigation, it could be like 100 times that. So be careful.
Yeah, I was gonna mention, I'm sure, Sam, you have some clients where, they made a will, but they didn't make a trust. And I think one of the main questions that people have that are watching is, maybe I made a will, but how do I know that I need to make a trust? Because I know if you make a will, you potentially could still be going to probate, and if you didn't create a trust. So what would be the difference between just making a will or making a trust? And let's say, again, you made a trust, but you never funded it, you could still see your day in court and probate, right?
Right. So part of our initial consultation at my firm, and I'm sure at Leslie and Leanne's, is doing an entire evaluation of someone's assets and their goals. So that happens in the initial consultation. At that point, that's where we give our recommendation of whether someone needs a trust or not. Not everyone needs a trust. Some people need certain types of trusts, right? There's a ton of different trusts. So it just depends on our analysis and what that family or what that person has and what their goals are. And then from that point, if they don't take our recommendations, this happens all the time for me. They don't want to put the investment in trying to establish a trust. And it's so hard for me to see them do that, because what I tell them in the initial consultation is whatever you're going to spend, 1,000, 2,000, whatever extra you're going to spend on the trust, establishing it and funding it is going to save you. Right now in probate, you're looking at no less than 5,000 to 10,000 for an administration. So it just depends on if you want your family to spend that later on. And that's at the very least. I mean, there are probates that you can spend hundreds of thousands of dollars, even in an administration, without litigation sometimes. I mean, it just depends on the situation. So it depends on someone's goals, if they want to spend it now during life or have their family spend it later on. And what their assets are. I see Marissa's question, and that's probably where you got yours, Melissa. How do we know a trust is the right tool? It depends on your initial consultation with the estate planning attorney. And if you get an attorney that's not dabbling in 10 different areas of practice, they'll be able to specifically tell you, money aside, this is what I would do if I were you. This is what your family would want if if anything were to happen to you. And then it's your choice at that point. And then just to connect to what Leslie and Leanne were saying earlier, I send out a letter. I think Leslie said the same thing. After your trust is established and your estate planning is established, I send out a letter basically saying, here are the responsibilities now for funding. If you'd like to hire us for the funding process, you're more than welcome to, or you can do it on your own, and here are the instructions. So I give them both options. People don't usually do it, though. That's the problem.
Yeah, they already think that taking that first step and making the trust is enough, and then they never go back.
I will share my estate planning clients that come to me because they have a special needs child that's maybe a minor, and they're looking to protect that child, and they're specifically looking, maybe grandparents or other family members want to include that child as a beneficiary of their plan, their estate plan, and we set up a special needs trust. I will tell you, those are my straight A clients. Like, they are on the ball, they do everything. And I don't want to make it seem like our clients are all like, lackadaisical, not doing their jobs. But those clients with a special needs child are definitely getting the plan in place.
So I have come across a couple questions that have come into the chat. We had another question that was sent. It says, what exactly is a trust and when do you need one? Again, Sam had addressed that one. It's better to go get consultation. I mean, estate planning is tailored to every case. It's a case-by-case basis. Not everyone has the same plan. But I have another question here. Should you notify people that you plan to leave assets to?
No, absolutely not.
I was like, that's a value judgment, not a legal question, but okay.
I think Sam and I, thinking about it from like a litigation perspective, no, because then that person is going to stomp into court and show the judge, look at this email I got in 2020, the day after she went to her attorney. I'm getting X, Y, and Z. And don't share documents. Don't send your documents to, when you because I know all 65 people are going to go to their documents after this. Don't email blast them to like the 5 fiduciaries that you pick. That's another part of this conversation. I typically have it at the end when we sign. And I usually follow up in an email, like, remember what we talked about. Don't forward this.
I think maybe,
and the reason for that is you're going to change your documents in a perfect world a million times before you pass. So just because you leave, Sally $10,000 today doesn't mean you're going to leave Sally, your daughter, $10,000 in 20 years. You could have a falling out. Sally could predecease you. It just depends. Or Sally's well off and you want to leave for her children's college fund, so you change your mind. So it just doesn't make sense to me. And Leanne hit it on the head. It's litigation. Once you share your documents and then you change them later on, that person is going to litigate in court, and they don't care what the cost is. It's a principal argument most times.
I think on the other hand, most people who don't have, millions of dollars and lots of assets, and they're just simply leaving, let's say, their home to their kids, not describing what's actually in the will, but still advising someone, hey, I have a will and it's in a safe deposit box, because there's also a presumption, right, that if you don't find a will, that the person doesn't have a will. And so maybe having one person actually know that you've created estate documents so that they know, okay, if anything were to happen, here is the place to find it, and it's a good location to have.
Yeah, I think there's a big difference between notifying people that are potential beneficiaries versus telling somebody that would be maybe your successor trustee or something, or your agent under your power of attorney. I mean, generally we have something that we call fiduciary letters. They're very, very vague. They're kind of like, you may be called upon one day, congratulations, to do these things for me if I need you to, because I've become incapacitated or I have now deceased. And this is where the documents are, right? Whether I hope they're not in the safe deposit box, but I'm hoping that they have it. And we do give people flash drives for that purpose. Like, here are the letters in the flash drive. If you want to email them, we give them the physical copy of the letters. What we don't want is exactly what Sam and Leanne just said. Don't go emailing your trust documents or your will documents to, the entire family or who's going to be beneficiary of these documents. But it's a whole different conversation about, if something happens to me and I become incapacitated, here's my power of attorney, or my attorney's holding the power of attorney, or whatever it is. But practically speaking, how do we use these documents? You're not paying for documents. Ultimately, you're paying for an estate plan, right? This is the plan if you become incapacitated. This is the plan how things should go if you die, etc. So, yeah.
Yeah, I definitely think, with this webinar, it's very important for everyone who's listening to see how important it is. You don't have to be 80, you don't have to have $1 million, if it's just living documents, whether it's just simply creating a will, it's not notifying the beneficiaries what they're going to get. These key takeaways from, this panel discussion is essential. We actually had a case where he was an attorney and he passed with no will. And, you'd think, oh, an attorney has a will. Well, he didn't have estate planning documents, and he had a partner for 35 years. Now, in Florida, we don't acknowledge common law marriages. So she actually could not inherit the money, a lot of money that he had. And his estate actually went to 19 far, far away cousins. So yeah, it was a crazy case that we had. And you think everyone who, you work so hard, you work every day to be successful, to own that house or to own that car, provide for your family, and then you think, oh, Florida's going to take care of my stuff. And in fact, Florida takes all your success and says, hey, I'm going to align it the way that we want to do it, rather than you taking the initiative and making your own documents and saying, I'm going to leave this. And, that's what you work hard for every day. But if anyone wants to share any other crazy story.
I'm not the litigator here, so you guys have crazy stories.
I'm going
hear
to
about
share a short one, just a short one, because it goes back to the point, my little soapbox, register to vote and do your advance directives. Early on in the pandemic, we got a call from two parents. They were divorced. They had I think he was almost like 2 days older than me. So he was in his early 30s and he was a young lawyer and he had COVID and he was at Baptist and they couldn't decide what to do. And they searched high and low for advance directives, hoping not to have to go before the court. And that's just like worst case scenario. Imagine being a parent, having to make these tough calls in the middle of a pandemic when we don't even really know what this virus was, April, May. And we had to go and get a guardianship for one of the parents, and the other parent got their attorney. And then we had to deal with the Florida bar to get somewhat like an inventory attorney, almost not necessarily an inventory attorney, but somebody to make sure that the accounts were okay and things were moving. So I think that's not my craziest, but I'm hitting the nail on the head with do your advance directives.
So I have two more questions in our Q&A box. I have here, if you choose a banking institution as your trustee/fiduciary for your estate, should you give a copy of those documents to the bank now, or should you leave it for once you've passed to be presented by the attorney for further disposition?
I mean, so withholding my opinion of certain financial institutions and their performance as trustees. It really depends. I see that the couple of clients that I haven't been able to talk out of this, and they did have good reasons for it, had a specific person, and that usually is the problem at this financial institution, that they are just like married to. Right. And the problem is that when they leave that financial institution, now all of a sudden we have an issue of we named the actual institution. And a lot of times JP Morgan itself doesn't even allow some of their bankers to do this or whatever it is. So there's a lot of moving parts with that. I would say that, yes, you want that person that you have known for 30 years and was your parents' financial advisor and everything else. A lot of times they have to actually get it approved, so they will have a copy. But there's just so many variables that go along with that I don't know if I can give you a very good general answer, honestly. And I've seen it go wrong a few times already. And now you have this institution that your parents did not intend to be really managing your money and billing off of your file and doing all of the things that they do, because the real guy that they trusted is now somewhere else. It's become a problem several times that I've seen over the last 10 years.
We are going to wrap up in a little after we have two more questions. How should I go about looking for an estate and trust attorney, and how can I know that they have my best interest? What's the best way to compare?
The only thing I will say is do not go to someone that does door law. So if you go on this person's website and they do like bankruptcy and crimim, some criminal stuff and immigration and whatever, do not go to this person to do your estate planning documents. It just doesn't make any sense. I think, any real practitioner that deals with these issues day in and day out are going to understand and know and be able to preempt so many problems and solve them for you, that would be my best advice. Just don't go to someone that's a general practitioner. Make sure that the person you're going to does estate planning. That's the best thing.
I always tell people, word of mouth. Ask your family, ask your friends who they've gone to, then vet that person. Look at the reviews online, have a consultation with the person. And if you feel comfortable during that consultation, I think that gives you an idea of whether you're in the right place or not. And not every attorney fits what you need. Just because somebody does estate planning doesn't mean they're your estate planning attorney. there are times that I'm sure Leslie and Leanne have also declined clients because they know that they're not the right fit. And you can recommend at that point, hey, I think you would actually do better with this person for these reasons. So it just depends on how you feel during that consult and what research you've done.
Leanne, could you explain to the audience what a living will is?
Sure. So a living will is a document that is used by your healthcare surrogate and your doctors at the end of your life, terminal illness, injury caused by terminal illness. You guys can help me. There's 3: vegetative state. What's the third one?
End of life condition.
Yeah. Okay. Well, my form breaks them out into 3 like long little paragraphs that defines it out, and then we list each of the different life prolonging procedures. And if you, for your personal reasons, feel that if you were in any of those categories, you sign it, and your doctors will not perform those life prolonging procedures. I think it's a really important document. It's part of that advanced directives. And I think it's really helpful for the healthcare surrogate. I have been in the situation where we're advising a healthcare surrogate, maybe a healthcare surrogate power of attorney and a trustee, and just having that document and knowing like, this is what grandma wanted, or this is what mom believed, is so helpful for them in that moment, that very, very emotional, difficult moment of making that decision. So I think it's a very important document. Thank you to whoever asked, because I don't think we talked about it.
Can I add one thing?
Yeah.
I also think it's extremely important, like Leanne said, because if you have a blended family, and she brought that up earlier, I deal with this in family law. If you have children from a first marriage, and then this is your second, third, fourth spouse, whatever it is, no judgment whatsoever. It's just easier to make that decision instead of having your family members fight to be able to keep you on life support or not. If your wishes are there, there's not really going to be a huge fight. It's in writing. This is what you want.
So we're going to close off with one last question, and it says, can we consider family that live out of the country as beneficiaries? And I think this is a great question because a lot of, us, the culture in South Miami, have a lot of beneficiaries that are all around the world even.
So the question being, can you have a beneficiary that's outside of the US?
Yes.
So the answer to that is yes, absolutely. But that just leads to the immediate, usually next question, which is going to be a practical question of how we, of course, get a hold of these people, find them, actually distribute anything to them, right? But number 2, the client usually starts asking about tax consequences. And there's a huge difference really between, can I make my brother who's in Buenos Aires my trustee, and what would happen to the tax ramifications of doing that and having a foreign trustee versus, okay, the beneficiaries are my brother, sister, nieces, nephews, whatever in Lima, right? Whatever it is. So those are 2 very, very distinct things. I think clients sometimes confuse them. But yes, absolutely. If your family, your loved ones, your whatever is in another country, you can have them as beneficiaries. And that's actually that's a much more practical problem than a legal one. If you want somebody to manage and control money in a trust for a period of time, and they're a foreign person, now we got to have many tax conversations. And the third thing I would say is, I do not give tax advice as to what the government of, Colombia, Argentina, Peru, and everywhere else is going to feel about the money that your brother just received. Because that's, of course, something that comes up too. Well, are they going to be taxed in that country? Well, you were going to have to ask an attorney or the equivalent CPA in that country to find out.
Definitely. If anybody I would like to have each one of you guys give a last 30-second message to the audience, key takeaways, what you'd like them to know, so that we could wrap up.
I'll go first because everybody knows what mine is going to be. Thank you for joining us. When you turn 18 or your child turns 18, get your advanced directives, register to vote. Be safe, wear a mask. Thank you so much.
I'll go next. Thank you very much for having us. This was a lot of fun, and it was really fun to connect with Leanne and Leslie, who I haven't seen since the pandemic has started. If anything, just talk to your family after today's talk. I know it might not be something you do today, right? You don't have to go to an attorney today or tomorrow, but talk to your family, talk to your parents, talk to your grandparents, and save them a ton of money by just having this conversation of the importance of estate planning. I mean, they don't need all of the documents that we've put in the chat, but maybe some of these will save you all thousands of dollars, and it's just important to have it. Thank you.
So I guess my 30-second thing I would like people to walk away from this is back to the minor kids, right? If you are a parent and you have a minor child, and I'm not really talking about so much, I guess, the 15-year-olds, because in an emergency situation where parents are going to the hospital and maybe totally incapacitated, you know, that 15-year-old probably has a nicer Beamer than me, and B, a better iPhone, right? So I'm not really worried about them ending up at Department of Children and Families or anything else. But if you have children that are young, you know, you are a parent and you have a responsibility to do some planning for that children. And I almost want people to think of that planning as like a separate thing. You know, we put it in a separate binder just so we get the point across here, but your children have their own quote estate plan. And so what happens to their money, of course, is one thing, your money that you're leaving your kids. But a whole nother thing is that permanent, you know, like the permanent guardianship, like the custody, like the child itself, and who takes care of them if you and your spouse are deceased. I mean, at a minimum, you brought them into this world. You have a responsibility to make sure that they don't end up in total chaos when they have possibly just lost you as their parent. So.
Thank you, guys. I wanted to give a big thank you to Professor Rodad. She is the reason many, I think not all of us, are estate planning attorneys today. She was a great professor, and she always tries to keep the FIU family together. So we're very thankful for that. And for everyone who's watching, we are recording this panel discussion, so it's going to be available on the website of College of Law. So you can go ahead and find it there and send it to anyone that you think needed to hear this message that wasn't able to attend. But thank you guys for watching, and we hope that not only you learned, but that you do, and that you can call any of us if you need any estate planning needs, and we're here for you. Be safe, and happy holidays for everyone that's coming up. Just make sure you're safe with family, okay? Thank you, guys.
Thank you. Bye.
Bye-bye. Thank you.